Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Domingo Matias. Section 78 of the Criminal Procedure Act provides that the court may order that a person charged with a crime be subjected to a psychiatric examination to determine whether the person has the mental abilities to stand trial, and if so, whether by reason of mental illness or defect the person is criminally responsible for his or her criminal act. If it is found that the person is not responsible for his or her criminal act, Section 79 goes further to say that the court may, for the purposes of the relevant inquiry, commit the accused to a psychiatric hospital or any other place designated by the court for such periods not exceeding 30 days at a time, as the court may determine from time to time, and where the accused is in custody, where he or she will be committed. Today, Rights and Recourse, we explore this generalized anxiety disorder phenomenon with its relation to the Criminal Procedure Act. This is Rights and Recourse. But before we get into today's discussion, let us take a look at this insert.
In my view, the question is whether the applicant, that is the state in this case, has made out a case for the relief that is sought at this stage. If it has, I fail to see what the evidence of this other witness would be, or how it would assist this court to determine whether a referral as sought by the state is warranted. Counsel for the defense submitted further that the cases that were cited to this court were distinguishable from the present case, and that in most of them it was clear that there should have been a referral, while in the present case there is no substance to the allegations. The cases may indeed be distinguishable on the facts, but there is the required substance in both the report and the evidence of Dr. Foster. And as I said earlier, this cannot be ignored. In any event, the test remains the same, irrespective of the circumstances of the case. The question is whether there was a reasonable possibility that a referral of the accused for observation in terms of Section 79 of Act 51 of 1977 would reveal inter alia that at the time the crime was committed, the accused suffered from a mental disorder which could have resulted in his not being criminally responsible for his act. Having regard to the facts of this case, I'm persuaded that the requirement of a reasonable possibility has been met. It is so, as counsel for the state submitted during argument, that a referral inevitably means more delays in finalizing this matter. But this is not about anyone's convenience, but rather about whether justice has been served. It is necessary to emphasize that an application of this nature is never taken lightly, as it is an integral part of a fair trial. Having regard to the above, I am satisfied that a case has been made out for the application or the relief as sought by the state, and I shall grant that order. However, the specific order itself will be handed down on Tuesday.
That's our discussion for today. To discuss this topic is Ms. Brenda Waddle, our legal commentator from the Brenda Waddle College of Law, Dr. Eddie Park, a psychiatrist from the Psychiatric Hospital at Sterkfontein, and in our Cape Town studio we'll be joined later by William Griffiths. Oh, there's William Griffiths in our Cape Town studio, a psychologist from the Clinical Psychologist Forum, who joins us from our studios in Cape Town, as I said. Yes. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse.
Thank you.
Good afternoon.
First of all, the question I want to know, what is generalized anxiety disorder? Do you want to take a first peek, William?
Yes, I think generalized anxiety disorder is a General anxiety disorder, it falls on the spectrum of anxiety disorders. It's one of the anxiety disorders. Others people might know is post-traumatic stress disorder, OCD, separation anxiety disorder. So it's a generalized anxiety disorder. It's characterized by a general sense of nervousness, anticipation. People tend to be edgy the whole time and describe themselves as nervous. So it's a general condition.
What is its relationship to the Criminal Procedure Act? Brenda?
Well, the Criminal Procedure Act at sections 77, 78 and 79, and these three sections should be read as an integrated unit, because Section 77 essentially deals with capacity to understand proceedings, fitness to stand trial. Section 78 then deals with criminal capacity, and 79 gives us the mechanisms, as you heard Judge Masipa in this case saying that this is how this matter has to be referred. So all those disorders are not necessarily dealt with in those three sections, but they are referred to, especially in the commentary of the Criminal Procedure Act, but they play a key role because accused persons, firstly, must satisfy two tests. They must have both the cognitive ability, that is, to distinguish between right and wrong, and secondly, the cognitive abilities to act in accordance with such appreciation.
Dr. Pock, I grew up in a security where when somebody has been involved in a criminal act that is horrific, in a horrific criminal act, the first thing that would be said by the law, this person must go for examination.
You mean a psychiatric examination?
Exactly.
Well, the Criminal Procedure Act and the sections that are relevant in this context talk about the court being able to refer accused persons for mental observation if there is really any question about whether there was any mental illness or condition that could have affected their criminal responsibility at the time of the offence or fitness to stand trial.
My question is, isn't this done right at the beginning?
It usually is, but the Act does allow that at any point in the progress of the proceedings, the court is allowed to make that decision. So it often is made right at the beginning, but the court is at liberty to refer the person at any point.
Have we had something like this in South Africa before? We've had many of these kind of cases in my research, and many of those kind of cases happen to have been, those people happen to have been committed to prison rather than sent to a mental institution, if I may say so.
Yes, the concept of referral for mental observation, it happens on a regular basis because there is a large percentage of people out there that are affected by mental conditions and mental illnesses, and the conditions may have an impact on triability or responsibility. So the court should, in every case, consider the referral for mental observation so that everything is done fairly for the accused person.
William, down in Cape Town, I heard you say generalized anxiety disorder is some post-traumatic. You mentioned a very nice word there. Is it the same thing?
No, it's not the same thing. It falls under the cluster of disorders. If one looks at psychiatric diagnosis in general, one gets then the main heading would be anxiety disorders, and under anxiety disorders one would get separate disorders, which would then be obsessive compulsive disorders, post-traumatic stress disorder, and then under the cluster of some diagnosis of anxiety disorder is then generalized anxiety disorder.
What are the symptoms of this kind of thing? Are there any symptoms that one can see?
Yes, it is yes.
No, go ahead, William. I want this to be a discussion rather than a question and answer session.
Yeah, I think general anxiety disorder is quite a common aspect, because I think most of us suffered general anxiety or nervousness during the course of our lives, during the course of our everyday functioning. The symptoms, it's not a pathological condition per se. It is people that present with nervousness. They have worries, excessive worries about their finances, about their job prospects, about living situations, about the safety of children, stuff like that. It is so. In other words, it's quite a generalized experience of anxiety.
Well, when we come back, we will be talking about its relationship to the Criminal Procedure Act. If you want to join this discussion, you can call us on 011 714 6919 or 6918, or tweet us on Rights Recourse. We'll be back after the break. Welcome back to Rights and Recourse. And if you want to be part of the discussion, you can call us on 714-6918 or 6919, or tweet us at Rights Recourse. Let's have a look at this. Welcome back to, let's listen to Dr. Meryl Foster's explanation of the general anxiety disorder.
The factors mentioned in your report, in the fact that the accused, your view is that his GAD started at the age of 11. 11 months. Yeah. You've never consulted the father?
No, I didn't consult the father. That's correct.
But being able to take it back that far, don't you think that the father, being the only biological parent available, should be able to give you lots of valuable information?
It would have been advantageous to see the father, yes.
And what I also pick up is that at page 2 of your report, the accused attended creche and there were no apparent problems, so he coped.
He coped, yes.
But he couldn't have suppressed his anxiety disorder then, because children cannot suppress their anxiety disorders, they just cope or not.
Yes, it's harder to diagnose anxiety disorders in children of that age.
But okay, you know why I'm asking it, because that is your finding. Your finding is he suffered from GAD from the age 11, from 11 months, and it's getting progressively worse. So I'm going to go through this. He cannot suppress it at 17 months. If he was suffering from GAD at 17 months, everybody would pick it up.
No, the point to be made is these are the factors that would have contributed to the development of his general anxiety disorders. So that started at 11 months. So that would be a factor contributing to that development.
So
what I'm trying to show the court, my lady, is the early onset of factors that would have contributed.
Yeah, but then what I find interesting, Dr. Foster, is if you say it started at 11 months and at 17 months he was coping well, why would you do that? Because why would you say that at 17 months it has already started?
Because there's no doubt that children who have bilateral amputations at the age of 11 months see that as a very stressful situation, and that their development is different to children who don't have such similar amputations.
And I don't doubt it. I'm sure it would be different. But this is more specific. You made a finding, Doctor, that he suffered even at that early age from anxiety disorder.
I'm saying in my report that would be a factor that contributed to the development of his generalized anxiety disorder.
Welcome back, and thank you for that little piece. Dr. Eddie Park, you were saying something, you're mumbling something during that discussion there in court.
No, I was just trying to understand what was being said in court. I think the witness was saying that the factors that led to the development of generalized anxiety disorder started at that early stage, not that the disorder itself necessarily started then.
Can you start at that early stage?
The condition?
Yes.
I think it's
and
not...
resurface later. Go away and resurface later.
Well, I think it's very difficult to diagnose generalized anxiety disorder at such an early age. We're talking about at the age of under a year. It is a condition that tends to appear more slowly than a lot of the other anxiety conditions. And typically, when a person that's affected by it is in their 20s, 30s, 40s, often it's diagnosed at that later stage in the person's life. But I think what's being said in court there is that there are certain factors that happened in the accused person's life that may have contributed to the development of the condition, perhaps later in that person's life.
Brenda, in this case, yes, we saw the judge is actually calling for the accused to be taken to an institution where he'll be observed for 30 days.
Yes.
Can a case simply not come to trial because of the mental state of the accused?
Absolutely. If that person goes for evaluation and they found, firstly, that at the time of the commission of the offense, the person wasn't acting in appreciation of wrongfulness, or subsequently to that during the trial itself, that they do not understand the proceedings, that is not going to continue. But however, what I need to add from the legal perspective, and having regard to Oscar Pistorius's case, and I'm by no means trying to be a contemnor here, what I find very interesting, during evidence, even during the state's case, prior to the defense leading their own evidence, there was Samantha Taylor, who recounted or recalled an incident where Oscar thought he had heard an intruder. That is the first example. He asked her, did you hear that noise? Woke up his friend, went and investigated. Second witness is the gentleman who testified about the firearms, the licensing authority. When he took that test, he was declared competent because all his answers on handling a firearm were absolutely spot on. The third example is when the washing machine went on downstairs. He was armed. This is what the witness said. He was armed and he went downstairs to investigate. Not in any of those two instances did Oscar discharge a firearm. Now, what I don't understand, and perhaps the psychologist and the psychiatrist can assist us, is whether it is intermittent. So your generalized anxiety disorder affects you under the same circumstances, but on different days in different ways.
Probably, William, can you take a peek on that one?
Yes, I just want to latch on with what one of your, what the other guest mentioned. I think Dr. Foster's quite right when she said at a very early age it is plausible that anxiety or the generalized anxiety disorder could have starting to develop. I don't think that an 11-year-old would be, an 11-month-old child would be able to be diagnosed with that. Generalized anxiety disorder is actually one of the most commonly diagnosed or most prominent in children. Generalized anxiety disorder, if you look at the developmental history of a person that's inflicted with this condition, it usually started in early childhood. There's nowadays the research are looking at whether it's a prodromal condition, meaning that it might turn into OCD, panic disorder, or even depression. It's comorbid with depression in many circumstances, and it is not an intermediate disorder, it needs to be present most of the time in one's life. So it's not something that comes and goes. It is there. That's the reason why it has got impairment in daily functioning in people's lives.
It is said that he was found fit to handle firearms. Now, the question I want to know from the two of you, the psychiatrist and the psychologist, is should police, before they give you a license for a firearm, do a psychological test, a psychiatric test or a psychological test, on whoever wants to own a firearm?
Well, I can try that one. my personal feeling would be that it would be useful, probably, for some kind of a psychological assessment to be done, I guess, to see whether a person should own a firearm or not. Obviously, I don't think that is done, but sure, I think it probably would be useful.
But from a practical perspective, I remember when my partner had applied to renew his firearm license, they came to the house not only to check the safe, this, that, and the other, but to interview me on, does he get angry? How does he react when he is angry? So I think they do take that into consideration. Obviously, the responses by people are going to be different under different circumstances. If somebody wants a firearm, and we've learned through court that Oscar is an avid lover of firearms, he even collects them, that might not necessarily come out. But I think they do go to, as I said, from personal experience, they have actually asked those questions.
William and Dr. Park, probably you can answer this question for us very quickly. He goes to whether he goes to Westkop or to Sterkfontein or to Valkenburg. When he arrives there, what happens? What's the first thing that happens?
Okay, well, you've heard in court that the judge is thinking about possible outpatient assessment. So one way is that the person would be admitted into hospital where such an observation is conducted. Or not admitted, and the whole process is done with the person just coming to the hospital on certain days and going back home. If the person is admitted into hospital, then the person will undergo an assessment by a number of mental health professionals, including a psychiatrist, psychologist, and various other professionals. And at the end of a certain time period, a report would be issued to the court regarding his fitness to stand trial and his responsibility.
But what I wanted to know is, when I arrive at the sent to Valkenburg. I arrive at Valkenburg. What happens? What's the first thing that happens?
Well, I can speak for the hospital where I'm based, which is Sterkfontein Hospital. A person would be brought in by police, and they would be admitted into the hospital as per the usual admission procedures, and they would be admitted into the ward where the forensic mental health professionals would conduct such assessments. As per the Criminal Procedure Act, the period of observation is usually 30 days, and for the duration of the 30 days, then the person would be in hospital, in the ward, being assessed by various health professionals in the forensic unit of the hospital, and at the end of that period, be collected by the police again to be taken back to court, with the report for the court regarding fitness and responsibility. And then the court will look at the report and proceed from there.
Who does I heard the prosecutor and the defense advocate saying they will sit down and draft what is like. Does it happen like that?
To draft an order. To
draft an order for what should be looked for, and surely they should consult a psychiatrist.
Well, the psychiatrists and all the other professionals who are listed in the Health Professions Act, for example, it has to be a clinical psychologist, not just a psychologist, the psychiatrist, etc., etc., and obviously one who is actually elected or nominated by the accused person himself. With draft orders in court generally, and you heard Advocate Gerinel saying that the order will be ready. It's just a draft order. So the two sides, even though we have a very adversarial criminal justice system, they would actually come together and sit down and agree upon certain terms. Now, if you remember when Judge Masipa mentioned the issue of Mr. Pistorius being treated as an outpatient, Gerinel said that would be investigated. So I'm not quite sure what will make it into the final order. The other thing I wanted to say is that South Africa is not really a jurisdiction, a legal jurisdiction that concentrates on things like fear and aggression and emotional disorders. That you find more in countries, for example, such as the United States. And also the public are quite vocal. If you remember in 1982, the attempted assassination attempt on Ronald Reagan, and Hinckley was acquitted. Now, South Africa doesn't have a plea on the grounds of insanity. I'm not guilty on the grounds of insanity. And that is how he was found not guilty, that he wasn't fit to stand trial. And the Americans were absolutely outraged. And that is why sometimes it's critical to make that differentiation between legal guilt and moral guilt. Yes.
I'll come to that. I've got a whole lot of questions around that. But Dr. Park, William, you can also come in. But first of all, let's go to a break. And if you want to join us, you can call us on 714-6919 or tweet at Recourse. We'll be back after the break. Welcome back. If you'd like to be part of the discussion, you can call us on 714-6918 or 6919 or tweet us at Recourse. William, in Cape Town, you can come in and jet in as you want to come in. What makes up the... I read in my research about a DSM-4 model of classification of all of these things. And how do the psychiatrists decide on what set of model do they have to agree on which on all of these? William?
I think, yes, I think what you're referring to is the Diagnostic Statistical Manual. We are now at the 5th edition, not the 4th anymore. But I think, firstly, the psychiatrist, the clinical psychologist that evaluate a person for observation would need to conclude. Remember, the aim of observation is to see if a person suffers from a mental illness. So the DSM-4 criteria will be used to diagnose such a person, and that the criteria, the person's behavior, and would need to fit a certain set of criteria, and therefore they will diagnose a person with a certain mental illness in order to inform the court regarding the procedures that needs to be followed from there.
Breda, why would the defense in any trial raise issues of insanity or general anxiety disorder when he knows very well what might happen to his or her client in terms of Section 79?
Well, for a number of reasons, and the main reason would be the defense is there to protect the interests of their client. So by them raising that, they want the court, and we heard Dr. Foster actually saying that her conclusions and her findings would be relevant or could be relevant for both the conviction and sentence. And our case law is replete with examples where even the so-called insanity defense, because we've got pathological criminal incapacity and non-pathological criminal incapacity, and then we have diminished criminal responsibility. Now, we've had cases in our case law where people raise that at mitigation stage, and they say, well, whatever it is, I have been found guilty, but when I committed the act, I didn't really understand what I was doing. And some cases have gone to the Supreme Court of Appeal, and they've been referred back to the courts to say, you should deal with it in this manner. One magistrate actually acquitted someone who hadn't even pleaded, and that was sent back, and they said no. Prior to that, firstly, you cannot acquit somebody who hasn't pleaded, but you have to refer them in terms of Section 79 first, and only after the report is back can the court then make that finding.
How do psychiatrists take a decision? What informs psychiatrists that a patient is ready to go and face a trial?
Okay. Well, one is always cognizant of the two aspects that must be looked at: fitness to stand trial, which is looking at the mental state of the person at the time of the assessment, and also whether the person can be held responsible for the alleged offence, which is the mental state of the person when the offence was committed. Yes. Usually that's at two different times, and sometimes quite far apart. How do we assess? It's pretty much a general psychiatric assessment that we do, as well as a physical assessment, and to see mainly, is there any mental condition, mental illness that is affecting the person right now or back then that could have in any way affected the person's ability to tell right from wrong? If they could tell right from wrong, could they have stopped themselves from acting wrongly if they did have the knowledge of right and wrong? And different mental conditions can affect these faculties in different ways, some more than others. So we look for those conditions.
William, can a patient be treated as an outpatient? Because I seem to understand at some stage during the trial, it was said Oscar is taking depressants and all of those things. How would that affect the treatment?
I think, again, as an outpatient would be difficult because I'm not aware, or I cannot think how they are going to structure that. It's an unheard of, maybe one of your guests can assist me, but it's an unheard of procedure to have somebody come in for observation as an outpatient. I think normally if somebody enters into the hospital with a pre-existing condition, taking medication, I think it would not be stopped. Again, I speak under correction, but I don't think the medication would be stopped. He would continue his treatment.
You want to say something?
Yes. Usually observations are conducted with the person being admitted into hospital. However, outpatient observations can be conducted. But there are advantages and disadvantages to both processes. I think it usually is easier for the observing team, the assessing team, to have somebody in hospital with them for the duration of the observation period, because then they can spend more time with the person. The quality of the assessment may be better. The assessment is easier because there's always somebody with the person that's being assessed at the hospital, so that would be preferable. And certainly, according to the Acts, the major offences such as murder, rape, those kinds of cases will involve the accused person being admitted into hospital for an observation to be conducted.
Brenda, in my research, I came across a paper by Professor John Milton from the University of Natal in Pietermaritzburg. He wrote this paper in 1989, and he says he reckons that defendants who are found not guilty by reason of mental illness upon acquittal should be ordered to undergo psychiatric examination to determine their present state of mind, and should also be conducted in terms of a Mental Health Act. What's the difference?
Now, the provisions of sections 77 to 79 are explicit in that they have to be read together with the provisions of the Mental Health Act. And when that paper was actually written, the Mental Health Act was amended in 2002. It came into operation in 2004. And obviously it had a section, I think it was 79, that dealt with transitional provisions. But indeed, it sets it out very clearly, and the Criminal Procedure Act sets out very clearly the position or the procedure that has to be followed. But specifically, I think it was 2007, we had the Criminal Law Amendment Act, as Doctor said, that deals specifically with offences such as murder, culpable homicide, rape, any other extremely violent offence. Those have to be referred.
There's also the issue of, in my understanding, I don't know whether we still have that, we still have, when a person has been committed to a psychiatric hospital, and he cannot come back to court and stand trial, that person is committed to something extraordinary has to happen for him to be released. He remains at the psychiatric hospital.
An application would have to be made to a judge in chambers in terms of either section 47 of the Mental Health Act or in terms of section 37 of the Mental Health Act. So,
yeah, you see, if an accused person is found not fit to stand trial or not responsible, that's where the Mental Health Care Act comes in, and the Mental Health Care Act then says that that person must be, for a major offence like rape or murder,
yes,
that person must be ordered to be a state patient, a patient of the state. And that person is then, as a state patient, admitted into a hospital or a psychiatric hospital for care and treatment. However, because of the legal context under which they're admitted, they're managed slightly differently in the hospital in that for example, the discharge process involves the courts. Yes. And so they're treated as any other psychiatric patient would be treated in terms of the illness that they're suffering from, medications and so on. But when it comes to time for discharge, for example, an application is made to the courts, and ultimately the judge in chambers makes the decision whether to discharge or not. So those aspects are different from the ordinary, typical mental health care user in a hospital.
That was exactly my question earlier. Why would defense then bring up this issue when they know very well, should the person be found to be not capable to stand for trial, he will be in a mental hospital for the rest of his life?
Well, that would be more onerous and more burdensome, but that couldn't have been their intention. I think during cross-examination, and a doctor and I discussed that briefly, and he cautioned against it, but during cross-examination by Gerinel, Oscar Pistorius did allude to the fact that I couldn't remember my lady, I couldn't remember. And with amnesia, there are basically two types loosely classified, which is your true amnesia and retrograde amnesia that comes about as a result of suppression of whatever traumatic experience. We don't know at this stage what the report is going to say. So I think we shouldn't preempt. Let's allow the health professionals to conduct the evaluation and then see what they say.
Who appoints the psychiatrists? William, you can come in from Cape Town.
Yes, I think they are appointed, as I think somebody previously mentioned, that they are appointed by the court. I think both the state prosecutor and the defence team can sit together, and I think they make a decision regarding the panel. The panel consists of clinical psychologists and psychiatrists, and it's usually 4.
Well, that's it for now. We'll go to the break, and when we come back, we'll pursue this issue even further. Don't go away. We'll be back right after this. Welcome back to Rights and Recourse. Dr. Park, you mentioned earlier that a patient in this condition can become a state patient.
Yes.
And we did speak about the fact that it can only be released once a judge has made a decision in chambers.
Yes.
Why in chambers? Why can't that decision be made in public, in an open court?
Well, I don't know the reason why the Act was written that way.
Brenda should help us. Why in chambers?
Well, basically in chambers because that evidence is sent. Remember that it is the court that referred the accused person in the first instance. So if there is a reassessment and sometimes there's even prognosis, and then the judge would order the person to go and stand trial, depending on why they were actually institutionalized. So it's a decision. There are no arguments. So it wouldn't even necessitate that the decision be taken in an open court.
I guess.
You were adding something to...
No, just to say that when an application is made to the judge, they're presented with all the clinical medical information as well as, and they also obviously have access to all the legal information as well. And yeah, there are no arguments in court.
Yes.
The judge will look at all the information before him or her, and then make the final decision whether to grant or not.
Yes.
Which can be, you said earlier on as well, that a state patient may be in hospital indefinitely. Not necessarily the case. A lot depends on the mental condition that's being treated by the team at the hospital, and also perhaps an assessment of risk in terms of risk to the person himself or others. So a state patient may not necessarily be in hospital indefinitely. They can be discharged from that hospital, again, through that process described.
Can charges then be brought back if he was found not guilty?
If you've been found not guilty and you are sent for evaluation and thereafter sent to the institution, yes, if the psychiatrists come back and say this person is now fit to stand trial, then indeed you do stand trial.
William Downing Cape, have we had in South Africa successful cases of this kind where people were sent for observation and they come back and they stand trial?
Yes, I just want to add to the discussion. I think what is important, I think if one listens to the discussion of being admitted as a state patient and the procedures that coincide with being discharged, I think one needs to realize that this is usually linked with quite severe psychiatric illnesses. It would probably be linked to the psychotic illnesses. So I seriously doubt, I'm just scared one creates the impression that there's a chance that Oscar Pistorius might end up as a state patient, which I sincerely really doubt that. I don't think it's a condition that under normal circumstances would be valid for somebody to be admitted as a state patient.
Well, I just want to make the point, too, that we are not in any way in this program trying to suggest that it just happens that we're discussing this issue, which is a very important issue, and this case is is a case study that we are using. Now, I'm not talking about you, William. All of us here must take responsibility for that. And I just want to come to something else. Professor Milton also argued in his paper that the onus for the presumption of a person to be sane should rest with the prosecution. Would this not open the door for an appeal?
Well, that was prior to the amendment of the Act. As I said, the paper was written earlier. It is only on the prosecution if it is non-pathological criminal incapacity. The onus remains on the prosecution. But if it is the defense, as in this instance, who introduce evidence of mental illness, they must then prove not beyond reasonable doubt, but on a balance of probabilities that he didn't have the criminal capacity to commit the said offense.
It's always nice to use these very nice terms, balance of probabilities. Now the two psychiatrists with me here. Academics still believe that the exact nature of the relationship between crime, violent crime, or non-violent or mental illness is still remains elusive. In other words, we might say a person is ready to go on trial, and the person gets there's a recurrence.
Well, yeah, it's hard to talk about any direct link between mental illness per se and criminal activity. It's not to say that somebody with a mental condition has a higher risk of breaking the law or the other way around. That's why I think it is the safest thing to do for any court is that if there's any question about the mental state of an accused person that could affect triability or responsibility, then they need, because the court does not have those expertise, then they should refer the person for observation so that the necessary professionals can help them make decisions about the person with a history of mental illness.
I think that is actually a brilliant point that is raised, because if you remember, Judge Masipa kept saying, we as a lay court. Now, the only time lay is normally used in court is in reference to everybody else who is not legally qualified. But in that instance, indeed, it is the psychiatrists and mental health professionals who can make that determination.
Somebody made a point. Somebody made a point during the course of the trial that if these are the things that are being put forward as things that might have caused this anxiety in the accused, then surely the majority of South Africans, especially those who grew up in apartheid times in the townships, should be suffering from this general anxiety disorder. Am I wrong?
Well, that's the thing. I think it's important not to. I think it's important to distinguish between normal worrying and an illness, a disorder. Generalized anxiety disorder is a condition where the person worries excessively, so more than what's expected for any given stressor or problem, and that is very persistently present, that excessive worry, and the person has difficulty in controlling such worry to such an extent that it often affects how they can function on a day-to-day basis. So we're not just talking about normal worrying, it's more than that. And I think it's important to distinguish the two. And you're right, in South Africa there are many things that we're all worried about. We don't all have generalized anxiety disorder. It's when it reaches those severe levels and it affects functioning where we talk about it being a disorder.
I want to hear William's comment on this issue that I raised with all of the things that are happening in townships and in squatter camps and all of the areas around there. Many people who live in those areas surely should be suffering from this kind of condition.
I think, again, one is probably exposed to anxiety-provoking situations throughout one's daily life. I think, again, one needs to distinguish if one reflects to maybe somebody that has been hijacked or somebody that lives under constant fear of being attacked or being burglared. I think that one would say we would rather look at traumatic consequences of anxiety, meaning PTSD. I think anxiety is part of our everyday life, and the possibility of developing a post-traumatic stress disorder, I think the conditions you describe is probably much higher than generalized anxiety disorder. I think generalized anxiety disorder or anxiety is part of our daily lives. We try to manage anxiety, and anxiety per se is not, per definition, a pathological condition. But for anxiety, we can maybe, like studying for an exam, we can use anxiety in a healthy manner to sit down and study. So I think anxiety per se is not necessarily a pathological condition. It's how it affects your awareness that brings in the pathology.
Well, we thought let's go to the break. That's a good time for us to go to a break. You can still join us here as we finalize this discussion. When we come back, we'll try and find solutions around this issue. What can be done to help people who suffer from this kind of anxiety? Welcome back, and thank you for staying with us here on Rights and Recourse. Brenda, what happens in the case where the defense has been arguing in terms of Section 115 of the CPA,
yes,
that the accused was acting in self-defense?
Well, that was the initial. The initial plea was a plea of putative self-defense. I don't know whether that is still the situation. And as I said previously, under cross-examination, it appeared that there was amnesia and a hint towards non-pathological criminal incapacity. And then the warning bells were then raised in Gerinel when the psychiatrist, Dr. Foster, was asked about the cognitive and the cognitive abilities. And that is where I think the defense, the state thought, let us rather err on the side of caution and go with the Supreme Court of Appeal and all the previous decisions, and rather refer him, rather than have a situation where he is convicted, he appeals, and that conviction is set aside on those grounds.
Dr. Park, what is the state of our institutions, psychiatric institutions, Falkenberg, Sterkfontein and Westkoppies? I know there are others around, so there's one in, we normally speak about the one in Queenstown. and the one in Grahamstown,
Yes,
and the one in Fort Beaufort.
Fort England Hospital. Well, I can speak obviously for the hospital where I'm based mainly, but essentially you're talking about state or government psychiatric hospitals, and such a mental observation process usually takes place in a government hospital where there is a forensic psychiatric unit. I think, speaking from our hospital's perspective, the hospital itself is quite old. Oh, there it is. And so the infrastructure and the buildings, for example, are often in need of renovation and so on.
See, somebody was raising the issue that the judge was having that in mind and
Yes.
saying probably Oscar should be an outpatient.
Well, I think, but having said that, I think the service that's rendered at the hospital, the healthcare professionals that are at the hospital, they remain of a high standard in terms of the service that they provide. Sometimes there's a shortage of professionals felt by a lot of hospitals because of lack of personnel, shortage of nursing staff is well known in our country in many different areas. So I would suggest that in terms of the service rendered in most of our state hospitals is of a high quality by the people that are involved. The people that are working at these hospitals are usually quite dedicated and they're quite cognizant of the fact that the infrastructure and so on, the facilities, resources are not very abundant. However, in such an environment, they give their best to render the services necessary. However, the buildings and so on can be a difficult issue at times.
Well, yes, we saw a vote of confidence in South Africa's psychiatric institutions was when Diwani was actually allowed to come to Cape Town, to Valkenburg.
Yeah, so again, I think in my mind there's no question about the kind of the quality of assessments or treatments that would be provided at our state institutions. It's more perhaps that the facilities or the infrastructure is not as
that's humane.
It's more in need of perhaps some renovation and that kind of thing than maybe some of our counterparts overseas.
Well, we hope that the MEC for Health in Gauteng is listening. You wanted to add something?
I wanted to add something, and I think with the LLB curriculum, and I studied under the new LLB curriculum, your forensic medicine is actually compulsory. You have to do at least one module. I took it up to master's level. But what I think is critical and should actually be recommended for LLB students is that they also do courses, even if it's just as we did in nursing, your psychology 1, 2, 3, or perhaps even just psychiatry 1, because then the courts and the prosecutors and everybody else would have a much, much clearer understanding of mental illnesses, because it comes up very, very regularly in cases, especially your violent offences.
Michael, William, one last word from you. It's been a testing time for psychologists and psychiatrists in South Africa.
Yes, I think it's also maybe on the positive side, I think it allows us to communicate to the people out there what we really do. I think it's important that people realize what mental health care professionals can do and the role they play even in the legal system, and I hope that this would allow people to have a different view on mental health in general and to realize that it is not something that is out there, it is with us and we need to address it and come to terms with it.
Well, this has been Right and Recourse. You must have heard Brenda speaking about nursing. She's a qualified nurse besides being a legal eagle here. This program is repeated at 10 tonight and at 5 on Monday morning. From all of us here, thank you to our guests and have a good afternoon.